are going to have our legal segment, and we have the team from Malik and Associates on air with us. We have attorney Joe Powell, who is going to be talking about, a particular subject that he will pick and which pertains to family law. And in case you have any question related to family law, I'd encourage you to call into our studio. For now, Joe, good evening. How are you doing? Welcome on our airwaves. Mind just letting us know what is it that we are talking about today?
But any question on family law, I've been practicing family law for over 30 years, and I've seen virtually every possible kind of case. I have some prepared notes. I'll be speaking in regard to a number of points generally about family law, but I don't want anyone to hesitate to call in and interrupt me, and I'll answer any questions anyone has. That has priority.
If you have any questions pertaining to family law, just feel free to call in. Do not hesitate at all. It could be related to child custody, child support, divorce, or anything else that, that comes to mind.
Well, I thought I'd kind of go over a lot of points about a multiple group of different family law cases and give people an overall picture of the process. I'm going to talk about some of the documents that are filed in virtually every case, and I'll also be talking about some documents that are only filed in specific cases, and I'll give people some understanding of how that works.
Sounds like a plan. Absolutely.
Yeah. I'll begin by saying that if somebody has a family law issue that needs to be taken into court, a divorce, an adoption, a modification, or whatever, they generally will come to an attorney's office. They'll sit down and discuss the situation, and we are able to use many years of experience in giving people some guidance. Some of it's not even legal. It's rather just good advice, like some things you can do with your children to kind of protect them from the issues that come up in family law, things like that. It's not always, in family law, it's not always about the law. It can be about what's going on within a family, and most family law attorneys are people that care about and try to help families in general. I'm always concerned, for example, about children in divorce issues, because they sometimes get caught in the middle. And one of the first things I'll say in that regard is the parents should do everything in their power not to put the children in the middle. Don't ask the children to choose, not even if they're 15 or 16 years of age. It's just not healthy, and the judges hate it. They do not want people talking to the children about the litigation. So people need to be very aware that number one, they can do damage to their children, and number two, they can be crossways with the court if they involve their children too much in a family law situation. Now, sometimes it's necessary to answer a question or two, but generally you let children know that these are adult issues, that the adults need to make these decisions, and that in some cases the judge of the court has to make the decisions. But the children don't have to be bogged down or worried about that, and they don't have to make the decisions. Keep the kids out of it as much as you can. That having been said, you've sat down in a lawyer's office, you've told them that basically the marriage is broken, you need to get something done, and divorce is the only issue you can really see as being the way to approach this. The way that any person starts any action in Texas is to file what's called a petition. In family law, it's often a petition for divorce. It can be a petition in a suit affecting the parent-child relationship. Now, that's usually when people are not married, but it can be used if somebody does not want a divorce but needs some decisions made in regard to children. The courts can do that. So a petition is basically a document that the attorney prepares, or if a person's representing themselves, they can prepare it themselves, but that can be difficult. But the attorney prepares a petition which tells the court what relief you want the court to handle by way of a court order or a decision by the court or a ruling by the court to take care of various situations and so forth. So the first document that's always filed in a case is the petition. Not every state calls documents by the same name. In Texas, though, a petition is filed, and the responsive document from the other side is one of two documents. It's either an answer, often called an answer by general denial, which just says, prove what you're trying to assert. We don't necessarily agree. And then the other possibility is a counter petition. A counter petition tells the judge what your side wants the judge to make decisions on. Now, once that petition is filed, it's often up to the parties and the court as to whether or not a temporary order may be needed. And if a temporary order is needed, this can be done by agreement, where the parties can do one of two things. They can either get an order of the court called a temporary order, and that temporary order is good as long as the case is on file and until the court changes that temporary order and issues another order. Now, if a case is eventually dismissed for some reason, temporary orders die. I've seen many cases that come up where somebody will have a temporary order in a case, and they will have a new situation, and they really won't realize that something needs to be done, and there's no matter before the court because the temporary order dies if the case is dismissed. And sometimes people think the temporary order still applies, so they don't worry about it, and then they've got something that's completely unenforceable. Once a case is dismissed by a court, temporary orders are gone. They do not apply. Now, not every case requires a temporary order, and sometimes attorneys can work out situations by agreement, and in that case, what is often entered is what is called a Rule 11 agreement. Rule 11 is just one of the rules of civil procedure, and it allows attorneys to get together, put their heads together with their clients, and sign off on an agreement that's enforceable in the court. The courts will enforce Rule 11 agreements and hold it against someone who violates such an agreement. Almost all cases can be resolved by that method, but not all of them are. Sometimes people are crossways and they just cannot reach a decision together. I encourage all people who are going through family law cases and experiencing situations with divorce, child custody modifications, whatever, do whatever you can to co-parent. Try to reach agreements voluntarily, because voluntary action, voluntary production of information, voluntary answering of questions from either side can save people a lot of money in attorney's fees. And I'm going to go more into that in detail if no one calls in with questions. Now, if a person can simply not afford an attorney, I want to let everybody be aware that a person can take a case into the court, what's called pro se, which is them representing themselves. Now, I don't recommend it. To me, a good family law attorney with the experience they've got in family law is an invaluable asset to use on a case. So a pro se response can be used if it's necessary, and sometimes people can get some help in their county law library. Every county that I know of has a law library in the county courthouse. So a person can put together some things and do some things themselves, and a court will let a person present their own case. But one of the big drawbacks to that is you're held to the same standard as an attorney. So if you're in court and you don't know what objections to raise, you don't know how to raise an objection, you can't stop somebody from bringing something in that's not supposed to be allowed. A good example of that is hearsay. Everybody has heard of hearsay, but a lot of times the people that are out there battling over issues in family law don't really know what hearsay means. What that means is any out-of-court statement, written or oral, made by a person to prove the matter asserted, that's hearsay. And a lot of people think that if something's in writing, it's not hearsay because it's not spoken. But a writing can be hearsay. If it's a statement by someone else, that writing will have to be authenticated, made acceptable to the court. So what I'm trying to say is, a person can represent themselves pro se, can take care of their own case if they absolutely have no other option. But I think we've got a question coming in, so I'll stop for there.
No, so Joe, you've made some very important points here, and there is something that I want you to further elaborate on in a question there. So you said that pro se is something that one can do, right? They can self-represent themselves, self-represent. But in this case, you know, the standards that the court sets, they're the same, right? It really doesn't draw a distinction between how an attorney represents vis-a-vis how an individual would, right? Now, my question is that for a spouse who's financially dependent, right, and who wants to file for a divorce, they really don't have the means to kind of pay these hefty attorney fees. How do they go about it? Like, do law firms have a process by which, you know, they would engage, you know, with somebody, they would start working for somebody, they would represent somebody, and then they would collect the fee once the court adjudicates in favor of that? Is there something like that, you know, that law firms typically do?
Well, I kind of have to answer two ways on that. First of all, every person that hires an attorney may have to come up with some money to get that attorney started. The attorney can't take the risk of basically loaning a person the money to handle their case. However, a person that's in the situation that you were describing, that's dependent on another person, if they can, in some cases, negotiate a pretty small retainer, and then the attorney can go into court and request a temporary order from the court that includes attorney's fees. For example, a lot of my cases, one of the parties may make $150,000 a year,
Right.
and the other party may be a stay-at-home husband or wife.
True.
And they take care of the kids. Well, the person is somewhat limited if they're in the situation, and some people are very controlling and won't release any money. So if a person has very little to work with, I would suggest at least coming up with a small amount of money to get a consultation. For example, in our firm, we charge $60 for a 30-minute consultation, and the main purpose of that money is not because we really need the money. It's because it encourages the person to show up for the interview, and if we don't charge anything, people just don't show up.
Right.
And that can be very frustrating for us. So it's basically you're just buying a little bit of our time so you can at least consult with an attorney. So my recommendation is for someone to talk with an attorney. Now, if someone is in a real bad situation and simply has no resources with which to hire an attorney, they might talk to Legal Services of North Texas. That's about the only avenue for people to get representation by an attorney without having to pay anything. Now, they're swamped, they're overloaded, so they can't take every case. But I do tell people that are in a real bind and can't get somebody started that Legal Services of North Texas is an answer. Again, consult with an attorney, see if they can make some steps to make it possible to get your case started, and then we'll get into court and see if we can get the more wealthy person to have to pay some attorney's fees. And the courts will often do that.
Right. And Joe, thanks for taking that question. And you know, where I was coming from was exactly what you alluded to, right? That it's not a level playing field. If somebody is making $500,000, right, and if they have to go find an attorney, they would probably engage a top law firm vis-a-vis this person who's financially dependent, right? And they're trying to kind of just make it happen. So absolutely, and thank you so much for answering that question. Folks, if you've just tuned in, I want to let you know real quick that this is our segment with Malik and Associates. We are, talking about family law and all the nuances and intricacies associated with family law. If you have a question pertaining to family law, and it could be regarding a divorce, child custody, child support, or anything else, then I would encourage you to call in now. Joe Powell, Attorney Joe Powell, is going to be with us for the next 20 minutes. Attorney Joe Powell is representing Malik and Associates. They are a top law firm in the Dallas-Fort Worth area. In any court case, right? So first is filing a petition. You file a petition and you ask for what relief you want from the court. That's step number one. Step number two is that you get a response document, which could be either a counter petition or it could be something else that I missed making a note of. What's that, Joe?
Well, the two basic documents that respond to the filing of a petition are either a simple answer.
Got it.
It's called an answer in Texas. It's called a response or whatever in some other states. But an answer or a more elaborate document is a counter petition.
Right.
The difference between the two is that an answer puts you before the case so that people can't just do something behind your back, but it doesn't tell the court what you're wanting. A
Right.
counter petition tells the court what relief you want. And so it's a little bit more extensive, and normally a counter petition is filed by an attorney, and an answer is often filed by somebody that hasn't yet been able to hire an attorney. So they file a simple answer. They might be able to go to the county courthouse and get a form answer by general denial that they can just fill in the blanks and file that. Most of the time, I would say 99% or more of the time, if somebody comes into my office and they have been served or they signed a waiver, I'll discuss that in a minute, they need to file what I think they need to file a counter petition, because for one thing, if things start going their way and not going the way of the person that filed the petition, if they've only filed an answer by general denial, the other side can non-suit and take the case out of court, and the person's left there hanging. But if they file a counter petition, their requests before the court are still active and the case is still active. So there's some advantages to a counter petition. It's a little more elaborate document. It takes a little bit more time, but it's a broader document that gives the court a view of what the other side wants in terms of their relief.
Perfect.
So now, if a person receives notice by getting served papers, they generally will have 20 days with which they can file an answer or a counter petition, and then they have the following Monday at 10 o'clock. And it's very important that they not ignore, nobody should ever ignore documents that they're served that have to do with a court matter at all. It doesn't matter whether it's divorce, immigration, civil, like truck accidents, car accidents. It doesn't matter what it is. If you receive a document from the court, you do not ignore that. You know, there's a lot of people that kind of live their lives trying to do as little as possible. You know, maybe they're not real proactive in terms of how they handle their business, and they ignore some things. Well, you can ignore your spouse to a degree. You can ignore problems with finances to a degree. But if you ignore a court, you may be subject to a default judgment, and that means the other side tells the court anything they want, and the judge will sign off on that order in some cases. So you lose all rights to your children, you lose all of your property, and if you wait long enough where an order can go into effect and it's too late to appeal, you may have no recourse at all. Some people think you can always back things up. Not always. If a court renders a decision, generally you'll have 30 days to file an appeal, and if you haven't done that, that order stands. Now, in family law, a case is kind of never over, because people can file a motion to modify, people can file a motion to clarify, people can file things to change and address changes of circumstances. maybe the person that originally had custody turned over a child to the other parent. Well, that parent needs to file a motion to modify, because if they don't, they're not going to get credit for the fact that they have the child in their possession now. Now, possession of a child might be a defense to contempt, but it's not. It's necessary in most cases to go back into court and make sure that there's a court order that has to do with taking care of the new circumstances and the change of custody that maybe the parties have done voluntarily. So you don't want to just leave everything hanging. Now, don't get me wrong. People can agree to do things voluntarily, but for example, child support, if no order is entered that changes child support, then that child support keeps accumulating, and it's the strongest debt in the world. It survives bankruptcy. It survives anything you can do. Child support keeps going on. It does not matter if the person receiving support tells the other person, you don't need to pay me. It's okay. That is not enough, because you've got a court order, and the courts can enforce child support 5 years later, and you may owe 5 years worth of child support plus interest. So I would encourage everybody that's listening, the one thing I want to make clear today, never, ever ignore what's going on in court. And if circumstances change, go back to court and let the court know what you need so that the court can render a new decision.
Joe, I just have one question on this.
Sure.
Is it very often that you see, somebody representing themselves and then getting a favorable decision? How often does that happen? Or how seldom does that happen?
Frankly, it's a little bit rare. Let me
Okay.
give you an example by way of, how circumstances can develop.
Sure.
If I go into court and the other side is representing themselves, I know what objections to raise. They don't know how to respond. So I raise an objection. If the judge sustains it, the person that's representing themselves may not know what to do. They can't keep going and keep trying to present that evidence. The judge won't let them. So it's not something I recommend, except that I do say that if a person is unable to obtain an attorney to help them, it is permissible to go into court, and the courts will generally let you have some leeway. But for example, one court in the area, Collin County, they're very strict about holding people to the same level of expertise as an attorney. And in that county in particular, it's very hard for somebody to handle a case effectively pro se. So it's not a great circumstance to be in, but do something rather than nothing. So at least get an answer filed where you are in court and you have a chance to have your say, and get into court. If there's a hearing set, get into court and try to express to the court at least what you're wanting the court to do. The judge will generally pick up at least on what you think is the right thing. So never ever do nothing. If it's a court matter, do something, even if you have to do it yourself. But if you can hire an attorney, you're way better off, because we've seen thousands of these cases. We've had a lot of coursework in law school preparing us how to deal with evidence and objections and things like that.
All right. And one question we got while we were taking a break, Joe, was that suppose somebody spends a lot of money during the court proceedings, and if they have set aside $10,000, $20,000, $50,000, whatever that amount is, dollars, they've spent that with a law firm, and suppose the decision is unfavorable, then is that sunk cost? Is that money lost, or how does it work?
Well, no attorney in their right mind guarantees a result. You simply can't do that, because you're dependent on the judge's decision which is usually a correct decision, but not always. And all an attorney can do is use their expertise to get the evidence into the court properly, prepare the evidence, and present the evidence correctly. And then the attorney's expertise has considerable value. Well, if a person is pro se, they just don't know how to do those things. I'm not sure if I may have kind of lost your question in my response. If you'd kind of give me a little bit better information or additional information if I didn't answer your question fully.
No, so that's the question that was asked by, a single mom, that suppose that, they happen to spend a lot of money.
What do you do if the attorney blows it?
Exactly.
Okay.
And you've spent a lot of money. Yep.
Yeah. If you've paid a lot of money to an attorney and they haven't done their job properly, if you can prove that, the proper response there is to look at malpractice. In the court, you have 30 days where you can file an appeal. Most judges most attorneys like me who practice family law don't do appellate work. It's a special area. But if an attorney has messed up, you have the right to file an appeal. But in a civil case, unlike a criminal case, ineffective assistance of counsel doesn't work. In a civil case, you have to live with what your attorney does. However, if the attorney has messed up and you can prove it, you can file a disciplinary action against them. You can also file a suit for malpractice. Now, I personally have never met an attorney that does malpractice. There are attorneys that do that, but I don't know any. A lot of attorneys avoid that because, attorneys don't like to go against other attorneys.
Makes
like
total
that.
sense. Yep.
But a person does have recourse. You can sue an attorney for malpractice. Most attorneys, including our firm, we have malpractice insurance so that we cover people if somebody has really messed something up. We've never had to use it, but we have it.
Sure. No, thanks for that.
Shall I keep going?
Absolutely, you can keep going, Joe. And I know that, you spoke about filing a petition, counter petition. You also spoke about a temporary order. You spoke about a Rule 11 agreement, at which point you also mentioned that I think you always encourage your clients to, and encourage everybody else to reach an agreement, right? That's the best way to do it. So yeah, you can actually carry on from there. And we've got about 5 minutes left. Yeah.
All right, that's good. What I'll go into next is there are certain things that come up in family law that can dramatically change the cost of the case. So I want to talk to people about information and the gathering of information. If both sides are smart, they will exchange information voluntarily and completely. They'll let the other side know everything they need to know. They'll answer any question that's asked. Why? Because voluntary information gathering is not expensive. You call the other attorney and you say, we need some pay stubs and some tax forms so we can kind of see where these people, where their resources are, what kind of money they have, how much money they make. We can get that information and people can provide that openly. That's not expensive, but the formal process of discovery is the other option. If people are not providing information voluntarily on request, then the attorney needs to file discovery. And there are basically 5 kinds of primary discovery. There may be a few that I don't mention that don't come up very often, but there are disclosures. And in Texas, every case requires disclosures unless both sides waive the disclosures. It's called Rule 194, if anybody needs to look, but that's request for disclosure. It used to be called request for disclosure. Now they're just called disclosures. They are required. You can't object to them. You have to answer them. There's some questions and some documentation that's required by disclosures. The second common kind of discovery is a request for production. That's where a person has to produce documents, photographs, tape recordings, or other things that they can produce and give to the other side, things they want to use in court. That's called a request for production. That's the first two kinds of discovery. The third kind of discovery is interrogatories. And interrogatories just means questions. Interrogatories are questions that must be answered subject to an objection, and the party has to answer those questions. So you can go into considerable detail with production requests and with interrogatories. Disclosures give people a basic overview of the case. They're helpful, but the more complicated instruments are often needed. The fourth kind of discovery material is a deposition. I'll go into that.
So, Joe, I'm so sorry. Sorry
next
to
week.
interject here. Yeah, we've got about 30 seconds here. So, any closing comments in 30 seconds?
Just that there's a lot of things to discuss in family law. I've gone through 1/2 of a page of 3 pages of notes. So, we've got a lot of things that we can talk about, and I'll see you guys next week. I'll be here.
All right, Joe, thank you so much for all those incredible insights and for walking us through the process, what all documents need to be filled up and what process does one need to go through. Folks, that was Attorney Joe Powell from Malik & Associates talking about family law. If you have any questions, then you can call their practice directly. The number is 214-881-2100. Or you can log on to the website malik.law. Time for a commercial break, but we are going to be back in just a bit, so you got to stay tuned.